If you've had questions on Dynamex case as it pertains to California law, here's a quick explainer that explains Dynamex versus Superior Court of LA versus AB-5, which is a statute, versus Prop 22, which is a proposition that modified AB-5. Dynamex versus Superior Court of LA is a case where a driver who was originally classified as an employee was converted by the company in 2004 into an independent contractor. The driver quit and sued the company, believing that he was misclassified and should be truly an employee. Now, the court, Superior Court, eventually this was appealed. The company lost and was appealed to the California Supreme Court, which held that the worker was actually an employee. And they didn't just apply the Barello test. They actually applied what is considered to be the ABC test, which predated AB-5 in California. AB-5 is the technical term of the bill, Assembly Bill 5. ABC is basically the three-part test, A, B, and C. So what is that three-part test? Well, the first part is that the hiring company cannot have control over the worker. So control comes in many forms. It could be requiring the worker to report daily, weekly on the status of the work, requiring them to wear a name badge, a uniform, anything that shows control over how the worker performs their work. Second part is the B part. The B part is where we examine the services performed by the contractor or worker. And what does the company do? Is it part of the company's core business, right? So you have a residential plumbing company and they're hiring a plumber, a residential plumber, to do plumbing services. It may be very difficult to show that that independent contractor worker who performs plumbing services, which is identical to the company, is really independent, right? An independent business that is a contractor. The third part of the ABC test, the C part, examines whether the worker has an independent trade or business. And this comes in many flavors, but really we're looking for people that have customers, right? They do advertising. They show themselves out to the public as being available to be hired. They have investment in their business, equipment. The plumbing example, they will have their own tools and equipment, which is not provided by the hiring company. They've invested in training, certifications, licenses. So some of these apply in certain industries and other things don't. But overall, the government is looking to determine whether this person has an independent business, a real one, and not simply that they're only performing work for this one company. That's AB-5. And basically those exact standards were applied in the Dynamex case as part of the holding of that court. So Dynamex was decided by the California Supreme Court in 2018. AB-5, which was written by Lorena Gonzalez and put into law, became effective January 1st, 2020. So if your company is audited by the state of California, typically the EDD in this case, they could apply two different factors. The original factors were 13 factors called the Barello test, and any services provided by your worker that predated January 1st, 2020 is going to be applying Barello 13 factor test. It's all the same factors. Those 13 factors got compressed into the 3 elements. And those elements now all have to be satisfied as of January 1st, 2020 for any services provided by that worker. So it's the same set of facts, but when you talk about factors, they're weighing like the scales of justice. So there are more factors in favor of employment or the worker being classified as an independent contractor. That was the Barello. That was a 13 factor test. The ABC test, or AB-5, requires all the elements to be met. Really, they're compressed into 3 elements. Everything has to be met, or the worker must be classified as an employee. After AB-5, Proposition 22 came on the ballot and was passed by voters in California. And what that did, it actually exempted only a very narrow classification of workers. And those workers were drivers, but it had to do with rideshare drivers, like the Uber drivers and the Lyft drivers, as well as the app-based delivery services like Grubhub. So those workers were automatically classified as independent contractors. It took that group of workers for that type of work and automatically labeled them as independent contractors. So it exempted them. So we don't have to go through the AB-5 test or the exemptions of AB-5 or even Barello, automatically classified. Now that's being challenged currently. So we'll have to stay tuned and see what happens with future court litigation and determine whether Proposition 22 is going to be overturned. But it's a constitutional argument. The state of California says, well, Proposition 22, which was passed by the voters, took away the power for the state of California to regulate the workers and the safety of the workers and whether the workers really should be classified as employee to make sure there's a level playing field, because the policy that's behind AB-5, Dynamex, and the future court actions is that they basically, legislators believe that workers are being taken advantage of in California by companies. So we want to protect workers, and that's part of it as well. Also, stay tuned, because on the federal side, the federal law could be being passed, and it's called the PRO Act, and it's going to be basically duplicating AB-5 on a federal level. So that no matter what state you're in, the IRS could analyze your workers and potentially, if you have misclassified workers, assess you additional payroll taxes, penalties, and interest. But that might duplicate what's happening in California. So if you have a company that hires independent contractors, analyze them very carefully. If you have an EDD audit, definitely hire a qualified tax attorney, someone to help you through the process to make sure that you're complying with the law. John Milikowski, founder of Milikowski Tax Law, thank you for joining us today.